second panel of this session will look into whether celebrity should be responsible for the products they endorse. Please welcome Roxanne and his partner, Ajit, being partners. Shwetasree Majumder, founder of Fidus Law Chambers. Ajit Ravindran, co-founder and managing director of Meraki Sport and Entertainment Private Limited. The moderator, Mahesh Bhat from MMB Legal. And I will be joining the panel as well.
Hi everyone. We'll get straight into this. The topic is quite interesting and we don't have too much time. I'm sure everyone's also very hungry. But to start off, thought would put things in perspective with two issues. There are different stakeholders involved in endorsements. We are aware of that. The critical aspect is the manufacturer product. Two is, of course, the endorser or the celebrity. And three is the consumer. We must keep in mind the fact that there is a shelf life for the endorser or the celebrity. That will be something that we will look into. At the same time, we must also keep in mind the fact that economics drives the whole game in this case. Having said that, if we look at it globally, there are different perspectives and different approaches that countries have taken. I'll try and put that down so that we can use that as a starting point. In Japan, for instance, it's very interesting where if there is any liability from an endorser, he has to come out and make a public apology. That's a very different take as compared to China, Hong Kong, where both the manufacturer and the endorser are held jointly liable. With that as a background, I'm happy to have this panel here, which is again completely across industry. We have Ajit, we have the legal aspects, we have policy, education. So I'll go straight off to Roshan, ask you a quick question here. Maybe you could give us some instances which you have seen and how the policy framework, enables it or disables it. How do you look at that?
Well, to start with, I think interesting to understand what endorsements are. So, endorsements are essentially advertisements, and advertising or commercial speech is recognized as a fundamental right in the Constitution of India. So, while it's not an unfettered right, it's a right for brands to inform consumers about their products. It's a right for the endorsers themselves to take part in these activities and to endorse products. And as I recall an ad that I saw when I was a kid, this was 20 years ago, but it was an ad on TV which said advertising is your right to choose. And it's that information that needs to be passed on to the consumer in terms of what the product is and what's in it for you really if you buy it. But that being said, I remember a quote from a really big actor about 10 years ago, in which in an interview he was asked about his promotion of products that were linked to alcohol. And all he said was, I'm not a promoter of good values, I'm an actor. So that's probably a good point for us to start with. There have been instances, of course. The ones that I can remember are Maggi noodles. There's Amitabh Bachchan, Preeti Zinta, Madhuri Dixit. The complaints filed against all of them. It was a matter that reached courts. More recently, Pierce Brosnan and his misadventure with the Pan Bahar brand. And I think there's just so many more that if you just put on your television at daytime and switch to any of the movie channels, you're just going to find so many infomercials. You'll probably look at them and wonder what's going on, as in why these products even being advertised, and how are the advertisers even doing it, the endorsers especially. To go off on a slight tangent, I think there's a slightly different approach to take if the endorser is a sports person, because then, in addition to, so while there are products that you can obviously endorse, there are certain times when you're competing in an event, there are certain times when you're representing your nation, when, unless you follow a due process or a prescribed process, you just cannot advertise any products or even competing products from the sponsors of the event. And eventually all it is an exercise in which all the stakeholders, whether it's the brands, whether it's the endorsers, it's, I think, lawyers, brand managers, who all need to come together and understand what's in it for the consumer and what's in it for the athlete themselves or the endorser themselves.
Thanks. Shwetasree, here taking off on the Pan Bahar example, what would, how would you look at that from a statutory angle? We know we have, the consumer protection side of it, which is now a bill, there is the act, we have different guidelines, but what's your take on that particular aspect? Any thoughts on that?
I think it's important to set the framework in place as far as celebrity endorsement in India is concerned. So, interestingly, the existing Consumer Protection Act doesn't even address the issue. But the bill, which is pending in Parliament, well, it's been pending for a while now, 2015, first substituted with the 2018 bill in Jan, that actually has a specific component about celebrity endorsement, which essentially recognizes the fact that a consumer who does not, essentially the same thing that is there with respect to manufacturers to say that if the product or the service, fails on a bunch of different grounds, and if the consumer is dissatisfied with respect to what it promises, then even the endorser would be liable. And what's interesting in that sort of a framework, and that really is the only statute where there is a penalty with respect to the celebrity, and if that were to come into, if that were to be enacted, then that would be a serious concern. But what's also important is that it has this little due diligence threshold, which, and we were talking about this earlier, to say that it's really problematic, because are you saying that the celebrity, for instance, if they're talking about a particular real estate company, so there was this apparently Twinkle Khanna and Akshay Kumar ad where they were endorsing that this particular real estate project had the cleanest air in the world. Now, as you know, that's a selling point if you live in Delhi, right? So, what are they supposed to do? Are they supposed to sort of go and check the air quality and if that were miraculously changing in that particular real estate, whatever space of where that property was located? So what is this due diligence threshold? Are you sort of simply saying that will be satisfied if the celebrity is endorsing a product or a service that they themselves are availing? I don't really know. So in the case of Pan Bahar, yes, I'd certainly like to know if Pierce Brosnan in between his sets of whatever he's doing these days is consuming Pan Bahar. Or closer home, I think that Vimal Pan Masala ad, I had read somewhere about the Delhi government issuing, the health department issuing a notice to Ajay Devgan about it. And essentially all of it stems from the the potential, and that's the interesting thing, because on one hand there was this whole flurry of negative PR, because of which Pierce Brosnan issued an apology saying, I was told it was a mouth freshener. So essentially all of it stemmed from the whole thing that, is it surrogate advertising for tobacco? So, when you're talking about surrogate advertising as far as tobacco and alcohol products are concerned, they're obviously put on a very serious kind of footing. But otherwise, generally speaking, if you're saying that the product or the service fails to live up to its expectations, and if the consumer is unhappy about that, then really you're coming to COBRA. But when it comes to the Advertising Standards Council of India and their guidelines, again, that's problematic, because that also has a slew of guidelines with respect to celebrities, and saying that a celebrity will basically not endorse a product. But again, what really is the enforceability? Because the advertising standard guidelines don't really apply to celebrities, because they can't enforce it against the celebrities. Ultimately, all that they can do is, and this is because of an amendment to the cable network rules in 2006, all that they can ask is that the television ad, that too if it's only on television, a television ad which is violative of the ASCII guidelines can be taken off television. So again, it's not really an action against the celebrity as much as against the ad maker as such.
I'll come back to you on that. Ajit, you are right now sitting with Pierce Brosnan. So, no, he's here. So,
four lawyers and I can't argue.
All right. So, give us your take on it. He's with you, and you have Pan Bahar in front of you.
So I'll probably share this in a slightly different point of view in that sense. I'll go back to the point that Roshan made in terms of what is an endorsement. He quite literally defined what endorsement is from a legal standpoint. But if you look at it from where we come from, right? So when a brand approaches a celebrity to endorse the product, the brand is simply or merely asking the celebrity to use his popularity and therefore give that brand a wider reach. It's as simple as that. It goes back to the conversation we were having. It's akin to what probably a Times of India does to brands, right? So if I'm advertising in the Times of India, that's because I'm using the Times of India's reach and network and credibility that I believe the Times of India has to establish my own credibility as a brand or a product that's coming into the market or is looking for a new product launch, etc. To this effect, if a real estate major who advertises on Times of India doesn't deliver on his promise, would you hold the Times of India accountable for releasing his ad? Because the actor or the celebrity or the cricketer or the athlete in this instance is doing exactly that. He's just he's being asked to endorse a product. There is a moral line, probably there's an ethical line which one has to kind of probably come to realize of his own. It can't be something that is instituted into an athlete in that sense. But if the endorsement, to me as a practitioner of these things on ground, an endorsement is merely a temporary arrangement. It's 1 year, 5 days, it's over. You have nothing to do beyond that. But the endorsement crosses that line of where the athlete or where Pierce Brosnan owns equity in Pan Bahar. Okay, then you are liable. Then you are responsible for what you've done as an action in terms of, because you are somebody who the world knows, you are somebody who the world recognizes. As long as Pierce Brosnan's engagement is those 3 days, he comes, he has to chew Pan Bahar and hit some people around him, and that ad is shot and that ad is put out, it's over. But if you tell me that he owns 2% equity, if he owns 0.2% equity, then you are with it. You're as responsible as anyone else in that sense. That's really my point of view.
Fair enough. Pierce Brosnan still in front of you. Don't go anywhere. Roxanne, now a question for you here in this context. From a contractual perspective, purely law from a contractual perspective, what has been your experience? What would you put in to safeguard the interests of the endorser and the manufacturer? You'll have to play both roles here. Even in the context of what we were talking earlier, what Shwetasree mentioned in that backdrop as well. So, any thoughts on that?
Yeah, look. So, I think from a celebrity's perspective first, particularly, I think we made the distinction between celebrity versus an athlete or versus a sports person, but just clubbing them together for a moment as the endorser. As they would be recognized in this context. I think, there's the element of due diligence that she mentioned as well, which is important. I think the simple fix is to think about things like indemnities and, that kind of contractual protection that they would be looking for in those contracts, right? So I think it's simple for you to put in an indemnity clause and say, to the extent that there's any claim, to the extent there's liability, you as the manufacturer or as the distributor, reseller, will hold me harmless effectively, right? I think that's the slightly simpler fix from a liability standpoint, and that really only takes care of, I think, to the extent that there's a monetary claim, and at least thus far, it seems to be, and we can talk in a little bit about the bill and the ban from endorsement and things, but largely speaking, it seems like the impact would be a monetary one, and then the indemnity kind of takes care of that. But I think the other thing that you can look to kind of use as a safeguard is to build in possibly some way in which you can perhaps at least take care of this diligence a little bit, right? So you ask for, beyond just the general indemnity, representations about the type of product it is that you're supposed to stand behind. Because that's effectively what you're doing when you're endorsing a product, right? You're standing behind a product. You are telling people that are going to look to you and look up at you in most instances, and tell them that this product is good, this product is something that I would use. I would choose A product over and above B product, right? So you look to kind of get the manufacturer, the seller, to stand behind that to you.
So, to give you an example, in the US, one of the requirements is bona fide use of the product. Now, if you were sitting on the side of the manufacturer or the product, how would you look at this, and what would you, just taking a contract, putting in a clause to talk about the fact that there is a representation or there's an indemnity, is there anything that you would recommend which could show that one is actually using it? It's a tough one, but I'm just going more on the proof of it.
Yeah, look, I think, to be honest, the way that you can kind of safeguard yourself best as a manufacturer is not really in terms of your contract with the endorser, but it's in how you run your ad campaigns. You need to be able to advertise responsibly. To be able to say, for example, that this is the cleanest air in Delhi, or this is the purest water from the purest spring from the highest mountain in the world. Like, is that correct? Right? I'm saying, have a think about how you're running your advertising campaigns and what is the nature of the brand that you're building. What do you want people to associate your brand with, right? These kind of overreaching, far-reaching statements and accurate statements is what is going to cause a problem. So, and if you're conscious in terms of, how you advertise your products, you don't really need to be looking for safeguards against the endorser. The endorser is doing what you are telling them to do most of the time, right? It's not like they're coming up with their own scripts.
Roshan, I have another question, slightly different take on what we've been discussing. In the past, we have seen instances where there is a team sponsor. Now, how do you look at that vis-a-vis the athlete or the sports person or whoever's involved in that sport? We could start, going a few years back, you can take Marlboro and Schumacher and Ferrari, for example. That's a team sponsor versus the individual who's sitting there. Your view on that? We have seen it decrease in the recent past, but it is still something which one cannot fasten a direct liability on.
I'm probably the worst person to speak on that, because when I got my first mobile phone in 2004, I got a Vodafone connection because they sponsored Man United. It gets worse. A few years later, I started buying AIG's financial products.
I'm just waiting for the time you take over Qatar.
But yes, I think it depends from person to person, I guess. But eventually, if you are someone who's influenced a lot more by the team than you are by an individual, there's also lessons to learn from that. For example, not every player will accept an award, for example, from the presenting sponsor.
Can I stop you there? That's a very good point. Now, this is a point which I would like to come to you on, Ajit, where you mentioned not every player may accept a prize from a sponsor because they disagree with the sponsorship. Has that been something that you ever come up against in your experience?
No, not in my experience with me personally, at least. But just going back to the point that Roshan made, maybe he's going to have cola fitting in his bathroom now next. But the point is that when as an athlete, I have certain frameworks that I don't want to kind of break or bend in that sense. So, like we discussed a little earlier, Hashimanga, and this is something that I can hazard a guess that from the day he made his debut, he wasn't established as a player or whatever, From the day he made his debut, he chose not to have the Castle Lager logo on his jersey. So now that is a framework that he didn't want to kind of break open in that sense. But so we've all noticed what happened in FIFA, and that's the example that you guys are quoting about in terms of not receiving certain things. But again, it's all about at what pedestal you are, at what level this is happening to you, at what point in time as an athlete for you is happening. That's really where it comes down. I mean, 10 years ago, it was the biggest thing or the most important thing for you to be the lead face of Pepsi or Coke in this country. I mean, I know an athlete or a cricketer who was making his test debut, but more importantly, he said that please make sure I'm the lead face on the Pepsi campaign. And today, you have an athlete or you have people who have chosen to say that I'm not going to do this. So it all comes back to at what point in life are you, or where you are, at what pedestal are you at for you to take these decisions actually. That's the reality. I mean, that's where it is in that sense.
So in your experience, I think this comes back to what I started off with on the shelf life of an athlete, it is, we can't really, I mean, as lawyers, and I'm also adding you to, our group here, as lawyers we can practice till wherever, but shelf life for athletes is very different. But how do you try to balance that expectation of an athlete vis-a-vis the requirement of the sponsor? So I could use that word.
So again, I think lawyers in that sense, and I'm not saying this because I'm here in a room full of them,
not everyone,
but I think this fraternity plays a very important role and often overlooked in things like what we do. I may take Nandan and Roshan's opinion seriously or not, but depending on what is on the table on the other side. So that's what it comes down to. And I think it's important for people like us, like I said, the practitioners of this, to be a little more cognizant of what this fraternity brings to the table. You guys are able to see probably 5 years beyond, 6 years beyond, which we may not have the objectivity, because at that time, all you're doing is looking at the economics of it. Looking at how do I make sure this happens, because I have to retain this athlete, I have to retain this brand. So there are compulsions. There are things that is beyond normal operating business lines in that sense. But to address your point, Mahesh, is that I think as an athlete manager or a representative of the athlete, our job is definitely to take a lot of cognizance or be aware of what the implications can be in that sense, and therefore have a sound legal opinion to kind of back you on all of these things. But more importantly, also to some extent, to whatever extent possible, exercise some amount of due diligence to see that this is not really going to harm the athlete's image or credibility in any way. I mean, 2 years ago, who would have had a doubt or iota of doubt if Nirav Modi came to them and said that endorse my product? Nobody would have even questioned and asked to show me your books or show me your how much loan you have or what is your thing. They would have just jumped in. So I'm saying, now how do you foresee these things? I don't know. Maybe you guys may back then also say, there is something may not be all clear here. But that's where I think a legal perspective or objective perspective, when you're not too closely attached to it, you bring an objective perspective. It doesn't have to be necessarily legal all the time. That's what is important, I guess.
Yeah, I think just one point which I think to add to this point about athletes choosing to be seen at least as endorsing certain products or certain services or certain brands. I think another thing to kind of think of, and I think from your perspective as well, is what brands they tend to associate themselves with, right? Versus, for example, who the title sponsor may be, or who sponsors the team, and how do you, I guess, address that kind of conflict? So if you have, for example, a younger player and for years has been associated with, Coke, just for example, and then suddenly Pepsi is the title sponsor, and how does that kind of conflict, and how do you try and plan for that, I think is perhaps, maybe something that ties in with the point.
Yeah, it does, Roxanne. Actually, today there's a lot of awareness about what individual endorsements are and what team endorsements are, and how these two things are intrinsically different, and how you can't really infringe on each other's rights in that sense. So there is a lot of awareness about it today, and I think a lot of large companies realize the opportunity of actually going the team way, because most often the team way seems to be cheaper than the individual way, actually, and that's the reality of it. To us, we're just in that sense, we're at a point in time where we're saying that we hope more and more athletes get endorsements in that sense, and that's really a point of where we are today in our sporting ecosystem in that sense, because a lot of times all of these things get garnered by actors and people from the Bollywood industry and all of that. So I think for us, it's very important to what we try and do, Roxanne, to answer your question, is that we try and to the extent possible. Like I said, there are many different dynamics that happen on a table, but to the extent possible, we try and match the core value of the brand with the core value of the athlete or the celebrity or the individual. So if there is a value match, then we believe that everything else is an expression. So if you say that it's the cleanest air in Delhi, that's not necessarily the brand's value, it's just the brand's expression in that sense. So maybe the brand itself needs to go back to its drawing table and say that, why am I using this as the peg? Why can't I just say that children can have a great time in my thing? I don't have to say it out loud that it's the cleanest air to breathe in that sense. So I'm guessing that there's a lot the brands also need to do in terms of it. But for us, and the role I play here is of representing talent managers or athlete representation, or people who represent athletes in that sense. We try and see if there is a value match, but it's all nice to say, it's idealistic, but not necessarily that it always happens. Really,
and it's not always business. So you're absolutely right. It's business actually is very myopic if you actually look at it in that sense. And if you are able to build in a strong value proposition, if especially if it's a budding athlete, right, Roxanne, if you're able to draw that out of the brand to give him that mileage, give him or her that mileage, that goes way beyond what the transactional nature of that association can be, monetarily speaking, at least. Absolutely. Brand loyalty, increasing, building a legacy. I mean, unfortunately, we don't have too many examples to give in our country of legacy. I mean, our best athlete has moved from Nike to Adidas to Puma. So that really is, that's the thing, right? And these are dynamics. I don't know what has happened, so it's unfair for me to pass a comment on it. But that's the fact of life. You should have stayed and you should have built legacy. Even today, Air Jordans are the ones that sells the most in America in that sense. Why? Because there's a legacy attached to it. And those are points where it's beyond money. It has to be beyond money. Sure. Shwetasree, I'll come to you on, maybe giving an example and just picking your brains a bit on this. There was an instance where, a tennis player came on a talk show and spoke about how she had undergone a laser vision correction surgery and it improved her rankings and she could perform better on the court. And also went to the extent of mentioning the clinic, the doctor, the cleanliness, the hygiene, the post-op care. I mean, I can stop there. But it was later on found out that while it did look like a chat they were having, she had signed a contract to promote that particular brand. Now, your take on that? And I would like maybe Roxanne to also add to that later on.
I think, and that's sort of going back to defining endorsement. And I think what's interesting in the Consumer Protection Bill as it currently stands is that endorsement goes beyond the traditional form of paid advertising. So endorsement really is understood to be that endorsement in any form, whether visual, whether oral. Essentially, the definition now hinges a lot more on perception, in the sense of if a consumer perceives that you are sort of giving your stamp of approval to a brand, then that is what qualifies as endorsement under the current scheme of the Consumer Protection Bill. So to that extent, yes, something like this would qualify, and then if the clinic was not able to sort of live up to the promises, then that would be an issue. I think where I find it interesting, going back to the point that the recurrent point that all of us keep talking about, that is due diligence. What's interesting is, again, that, in this sort of a scenario, I would believe that although there is no due diligence threshold laid down in the law, I would believe that the due diligence threshold would stand satisfied, because there is also a bona fide belief threshold that is laid down in the Act. And I think that on the bona fide belief threshold, if you actually are a user of the services and you've been happy, that would satisfy. Now, the counterpoint, does Virat Kohli need to have dandruff in order to be able to endorse an anti-dandruff shampoo? Should it be introduced? And then should he demonstrate that 99% of it is gone in order to satisfy the due diligence threshold? I'm not sure. What's interesting in ASCII is, and I find that funny too, because if you pay a fee of 25,000 and you sort of submit the advertisement for pre-approval to ASCII, then your due diligence threshold is satisfied.
And how much of a deterrent are the penalties, do you feel? I mean, for Rika, if it goes up to about 50,000 and it's primarily imposed on the product side, not really the endorser side. Any thoughts on that?
So, I mean, like Roxanne said, if you have an indemnity clause in your contract, then as far as the commercial aspect of the penalty is concerned, that could really be taken care of. I think what's interesting is, and that's why, and she referenced it when she said that there is also a ban component to it. So I think the ban component is where the celebrity gets hit as far as Cobra is concerned, because it says that you, in the first instance, you will be prohibited from essentially endorsing that product for 1 year. And that if there's a repeat offense, then it could extend up to 3 years. So that could be problematic as far as the celebrity is concerned, would hit the celebrity directly, and no amount of indemnities would take care of that. And then to that extent, it sort of separates out the liability of the manufacturer and the liability of the endorser. As far as ASCII is concerned, yes, like I said, it just takes the ad off the air, so it doesn't really impact the celebrity anyway.
Roxanne, your views on this?
Sure. Look, I think I think what I tell most of my clients on when they're acting as endorsers and when we do endorsement agreements is that the overarching principle needs to be good faith. These are people that are going to look at these products. These are people that are going to look at you as standing behind these products. And if you can confidently say whatever it is that you're saying, right, whether it's on a chat show, there's nothing wrong with making money out of it, right? If you went somewhere to a clinic and you had a good experience, and if you talk about that clinic, I don't think that's necessarily a bad thing to endorse that clinic. But I think that what you need to be able to, I think, have underpin whatever it is that you do is this principle of good faith. The fact that people are probably going to go and look up that clinic and want to go there and do, laser surgery because you've spoken about it and you have demonstrated through that conversation that you have, that personal experience and you have benefited from that as a sports person. And you're going to have young kids that, play tennis, play whatever sport that are potentially going to want to do that. And if you can stand behind that 100%, I don't think it's necessarily, a bad thing for you to make money doing that.
What about the insurance aspect? What are your views on that? Is that something which we see in the ecosystem today, which is prevalent? We know it's there in the West, and it ranges. It had a trigger effect post Tiger Woods, but any views on that?
Look, it's not, at least to my knowledge, I think that prevalent here as yet. Certainly, I know it exists as a product. I think that to be honest, with the kinds of amounts that you're talking about, just from a statutory perspective, I don't think it helps very much, or is very necessary, frankly, because the amounts are small, right, in terms of the monetary aspect of things. I think when you get into situations where you can have, class action, you can have damages, you can have, that scale, I think is, the kind of situation where insurance definitely becomes useful. I think if, again, you're talking purely from a monetary perspective, every endorsement agreement I've ever seen has indemnity clauses, regardless of which side is representing, whom. again, I think it's important from a manufacturer and distributor perspective that they can perhaps pay the premium and avoid, potentially the liability. I think it's less important or less helpful maybe from a celebrity's perspective because it won't help against the ban. For example, it will only pick up monetary, and in theory, at least, that should be covered anyway contractually.
Sorry, just one quick point to add to that. I think it's also important to remember that consumers are getting more and more aware of this. Unfortunately, there's a lot of, the Consumer Protection Act is quite abused. So I do know for a fact, I don't really know what happened with it because it kind of dropped off everyone's radar and there are no reported orders from the Consumer Protection, tribunals. But there was a class action filed in the Maggie scenario. So it's not something that we should exclude from the scope of our thinking because it could happen in the future as people get more and more aware of the financial potential of something.
Correct. Well, to me, it seems that it's primarily a question of how do you allocate the responsibility? Can we allocate responsibility? What needs to be done to ensure that the stakeholders are aware of who they are up against, what the consumers are looking at. With that, I think I will wrap up. We are out of time. Do we have time for a few questions? Yes, please.
So just to be very quick, we've spoken a lot about the responsibilities of the athlete and the celebrity in question. But speaking in a purely Indian context, doesn't the onus lie a lot on the brand, the corporate, and the sponsor? A, and B, on the representative who's advising the athlete? Because we know more often than not, there isn't a great understanding that the athlete has of what he's endorsing and how has it been communicated to him. And I think the gentleman who mentioned about how the best athletes move from 3 brands is a perfect case in this point. How much is there an understanding of what the corporate has vis-a-vis the representative? So is there something like on that?
Ajit, you want to take that?
So I think general consensus has been that there has to be responsibility which has to be shouldered on both sides of the table. The brand has to be equally responsible for what is put out there in terms of communication and creatives, and the athlete or the athlete's representative are equally responsible for ensuring that most contracts have the clause where they say that the creative call is the athletes, the final creative call is the athletes. So if you have that in the contract, it's no excuse for you to let something like that go on air, saying that it's the freshest air in Delhi. I mean, how do you prove it? I mean, unless you have technology, unless I know Honeywell is working on something. The world, okay. So I know Honeywell is working on technology that allows you to kind of create indoor air pollution is now the biggest thing, and they've come up with all of those things. So that's a whole different thing. But my point is, to your question, the point is that it's both ways because I think indemnity clauses in contracts allow the athlete or the celebrity to get away. So it's clearly there. In fact, if anything, I would hedge my thing that it's a 60% thing that the brand should enforce, that they are not kind of crossing a line or breaking a framework in that sense. It's not really the athlete. The athlete eventually gets away. I mean, like we'll all agree that it'll be in the news for some time, but they will fall off the radar in that sense.
I must also add to this that in what I've seen is in Europe, it's actually a self-imposed kind of regulation by the athlete or the celebrity, rather than it being a statutory or a legal approach which guides it. So it has different ramifications in different places.
In your laser surgery example, is the celebrity obliged to disclose that there is an underlying contract so that consumers not only are aware that something's being endorsed, but that you're actually being paid to endorse it as well?
Under Indian law currently...
Related to that, Ajit, are you endorsing Honeywell? Like clarity on that.
I think more advanced testing.
Under Indian law currently, no. There's no obligation that you have to. But if there were to be a complaint, then that sort of evidence would be introduced to show that this also qualifies as endorsement, simply because they weren't just making a good faith statement, but there was money that has passed. So that evidence would be introduced, but there's no obligation on the celebrity.
This sort of
No, I was just going to say, in terms of, I think it's certainly an interesting question, right? Regardless of whether you actually compelled to disclose or not, I think the question should be, should you be compelled to be disclosed? And I think that, certainly morally it's very easy to say, absolutely, how could you not be compelled to disclose, something like that? I think it becomes a little bit difficult in terms of where do you draw the line, right? There are people that have celebrities be paid to attend events. It's not just openings and things, it's galas, fancy up your art show in the neighborhood, whatever. Are you compelled to disclose then that you are attending that because you're paid and not because you support the artist? I think, it becomes a little bit difficult then, I think, to see where you actually stop. It's certainly, I think, a relevant question. I don't think the answer is necessarily that straightforward, though.
And related to that, I think some jurisdictions actually require you to state paid, a hashtag even on Instagram and other things, which also leads you to the question of who is a celebrity. If you're paid 100 rupees to forward or retweet, are you a celebrity and are you responsible? Let's say Maggie puts out an ad and there's a bounty for anyone who retweets of 10 rupees or 100 rupees. Is everyone who's retweeting a celebrity, or are you imposing a higher liability on someone just because they're famous versus someone else who's even influencing maybe 20 people who follow them?
Social media fame versus...
Yeah, I also feel that it's a mix and match of both. One is the self-imposed obligation on the celebrity, and two is the morality, ethicality of the issue rather than the legal aspect. I think both of those go hand in glove with each other.
With the way social media is evolving, Nandan, I think there are clearly two sides of the spectrum that is coming to the fore in that sense. One is, of course, the celebrity who exercises a certain amount of credibility and who people know and recognize, and therefore will use his celebrity quotient to kind of push the brand ahead. But there is an interesting development on the other side, which is called the influencers. Now, these are the people who are a product of social media evolution in that sense, and essentially now. While they were the trend to happen for the last couple of years, today if you see global brands like Unilever have taken a position to say that we will not go down the route of influencer-led marketing or advertising anymore, because we believe that is akin to paying for your retweets and your reshares and likes in that sense. So I think there is evolution. I think that social media itself is growing so fast, so rapidly on a daily basis that every day is a new day in that sense. So I think there are distinctions clearly emerging from that as well.
And legally also the distinctions exist, because a celebrity is really somebody who under the ASCI would have to be a celebrity, because there's like this little, you should have got more than 20 lakhs for the endorsement kind of financial threshold that is laid down. So, irrespective of how low that is. And it's also worded as a celebrity endorsement within the guidelines. So there it's clearly limited to celebrities and doesn't talk of social media influencers. But if you look at the structure of the Consumer Protection Act, it talks of endorsement in any form. There's a minimum threshold. So an influencer would, as long as they had a significant influence, would come within the scope.
Hi. So, in terms of public perception for a rational consumer in perfect direction, when you talk about association of a celebrity with a brand, and if the term endorsement is broadened to include liability of celebrities, how much do you think the nature of the product being pushed is going to put some liability on the celebrity in terms of the fact that if he's selling something which is an essential, like water or air, for that example, or if he's selling something like manure, for all I know, what kind of strict liability or a variable type of liability do you think should be put upon celebrities? Because mind you, the masses are being marketed to. So the extent to which they associate a celebrity with the product or the usage of that product. So how much do you think the liability should be for marketing essentials? And potentially, like, so if I'm marketing Kinley water and I find that the water is contaminated, what kind of liability should be passed down to a celebrity in that?
See, if I can just take this, to me, I think it's a question when you say an essential supply. It's a question between the product and the brand. Now, I personally would say the brand would be affected, but not the product. That's the way I look at it. I don't know if Roshan, any other view there, but that's the way I would look at it. So water would not mean that nobody would drink water, but yes, we would not go with Kinley, for example. Different take, Roshan.
Completely agree with that. It's also a question of, I think the state of play of law currently is to do a lot more with misleading claims. And in that sense, for example, if you're someone who's going and saying, if you wear XYZ shoes and they'll make you 25% slimmer in 6 months, like, which is a true case. Like a particular shoe. Roxanne can be a case study. But a particular brand was fined in the US, fined to the tune of $25 million. But the fact is, as a normal celebrity, if someone comes to you and says, do this, the contract also says that the information they're giving you about the product is confidential. So you can't really reverse engineer it. Right? I can't get anyone to have the shoe open, investigate the technology. But then I'm in breach of the contract myself. So I'm acting good faith, I have to go with facts that are on record. But also sufficiently protect myself.
I think the only additional threshold I can think of liability apart from the misleading aspect is if something like we were talking about earlier, if something is a surrogate ad for tobacco or alcohol, which is prohibited under the respective statutes, or if something is in violation of the Drugs and Cosmetics Act or the Drugs and Magic Remedies Act, where you're not supposed to advertise a pharmaceutical product or to make any claims that a magic remedy would cause some, So then those would have separate strict liability components in those statutes. So that's the only other thing that would kick in.
So in the bill, in the new bill, do you think in terms of association, does the bill take into account that if suppose like two years earlier I got a legal notice from a guy who lost his flat in Amrapali and he was suing Dhoni for it. So now the thing is that to what extent a consumer associates a product with the celebrity or his endorsement. Now does the new suppose you can't there are certain products with which you can't reasonably associate a celebrity to actually use, right? So Dhoni won't be using tongue or he won't be, doing something like that. So does the new bill curb endorsement, the definition of endorsement, to weed out these things? Because these can lead to long-term litigation. Because court interpretability is, it's something which is variable on these things.
I would agree with you. I'm just trying to understand. The question is, if you take real estate, how competent is a Dhoni to say that, I know what cement has been used, what bricks have been used, etc. That's
the underlying part of it. But it's also as if you know that I will not be actually using a product, but still I end up getting sued for that product. So where is the curb that you're just endorsing it and you're not actually using it? How can you control that perception through regulation?
Obviously, the statute is not going to be specific like that to get into individual instances. The statute speaks in general terms, and all of this will be evaluated on a case-by-case basis.
And also the due diligence aspect. Dhoni would have done some homework to see what is the quality of construction. What kind of people have bought it in the past. It would fall under the due diligence aspect.
Also, use and endorse. I think there are two different aspects to it. If I've gone to advanced hair studio as Shen won and I'm telling you that it has helped me regrow my hair, I have used it and I'm stating my point of view in that. But use and endorse, probably there's a view in that sense. I'm endorsing it. I didn't go and build the Amrapali.
One last question. Yes. I mean, there were two hands I saw. Yeah, go ahead.
So, in case if endorser is made statutory liable for any damages which occur because of the marketing, so does it make sense to give right to the endorser to have a say in the management or right to appoint an independent director in the management of the company? So that
the question is, should the endorser or the celebrity have
right to appoint a kind of a independent director in the board of directors? So that
to achieve what purpose? I mean, I'm just trying to understand what kind of a role would the endorser be?
So that that independent director can look over the business.
My personal view here again is that I think that would be a bit too much, because you have certain conglomerates which have different industries they are in, and they function as different entities. The board of directors, again, purely from a corporate law perspective, nothing to do with sports, but the board is responsible for the governance of the company. So, to me, advertising and marketing is only one aspect of the business. So, I would say that would be pushing the envelope too far. That's my personal view.
And I think there's also a built-in approval process, which a lot of times takes care of any concerns the celebrity has. Obviously, it depends on what kind of hold the celebrity has on and where he's placed in the market.
All right, thank you so much. Great discussion.
My guy is very he wants some custom, so I appreciate that. No, it's just I think the main one is the web harvesting. He doesn't want that much.